Hello, guys. Welcome back to our property law drafting series. I hope you enjoyed our last video and learned how to properly draft the operative part of a deed of assignment. In today's video, we're going to discuss the third part of a deed of assignment, which is the miscellaneous part. So I want to believe that you still have your scenario before you because that's still what we're going to be making use of. So all things being equal, after reading through our scenario, telling us how Chief Adiola wants to purchase a plot of land from Jumoke Kende for the consideration of 400 million naira. So let's say that in the bar finance examination, you are asked to draft the miscellaneous part of the final document to be executed between Chief Adiola and Jumoke Kende. And you are also asked to list the clauses and then to state the function of each clause. So let's see how we are to approach that question. So what are the clauses under the miscellaneous part of a deed of assignment? One, we have the indemnity clause, and then we have the acknowledgement for production and undertaking for safe custody. So how many clauses do we have for the miscellaneous part? Two, we have the indemnity clause, the acknowledgement for production and undertaking for safe custody. So let's talk about the indemnity clause. An indemnity clause is a specific type of covenant where one party promises to compensate the other for any loss or damage that may arise from a defect in title or breach of a covenant. Now, bringing it home to our discussion on a deed of assignment, right? An indemnity clause is that covenant where the assignor guarantees that they possess good title to the property, that is that subject matter of the sale of land, and that if there is a defect in the later future on the assignor's title, for instance, let's say that a third party successfully proved ownership in court against the assignee, the assignor by this indemnity clause is covenanting that he would compensate the assignee. So this compensation, you must understand that it even goes beyond the refund of purchase price. It also covers all the expenses during the course of litigation, all the filing fees and whatever loss that the assignee might have experienced in the course of defending that title during the course of the litigation. So you can say that this indemnity clause is like a financial insurance for the assignee, right? Such that if after payment of 400 million naira now, that is, Chief Adiola has paid 400 million to Jumoke Kende, if a third party, let's say 10 years after, or let's say 5 years later, a third party comes to challenge the title on that land, and then the third party is successful in that court proceeding. This indemnity clause is like a financial insurance saying that the counsel, right, to Chief Adiola can, on the premise of this indemnity clause, write a demand letter to Jumoke Kende citing this indemnity clause that was included in this deed of assignment and asking her to pay back all the litigation costs as well as the purchase price. Why? Because this indemnity clause has already guaranteed that if a third party challenge my title and then that third party is successful, I would repay the purchase price and also any ancillary costs in the course of litigation. So, how then do we draft this indemnity clause? The assignor hereby covenants with the assignee to fully indemnify and compensate the assignee against all costs, expenses, liabilities, and losses arising from any defect in the title of the assignor or from any litigation arising from a successful claim by a third party to the said property, which is the subject matter of this deed. So you can see that all the explanations we have had so far are well captured in the draft. So now let's move to the next clause, which is the acknowledgement for production and undertaking for safe custody. Acknowledgement for production and undertaking for safe custody. Now, in order to understand this clause, let me take you down memory lane on the activities in the completion stage in a sale of land transaction. Now, in the completion stage, this is the stage where the assignee or the assignee solicitor will draft deed of assignment. Also, after the signing and the exchange of that deed of assignment, the assignor is required to hand over to the assignee the original title documents of the land. This is the subject matter of sale to the assignee. So, bringing it home, Jumoke Kende, the assignor, is to hand over to Chief Adiola, the assignee, the original title document to that land. However, there are circumstances where it may become impracticable for Jumoke Kende to hand over the original title document to Chief Adiola. Now, let me give you a scenario. If you look at the image in front of you, there's a large expanse of land. Of course, you can see the demarcation of each of these, plots of lands. But it may be that this large expanse of land is covered by what is known as a global C of O, that is a global certificate of occupancy. Now, when you look at some of these real estate companies, now I'm not going to mention any because I was not paid to advertise for any, right? So let's just use anything random. Let's say XYZ, X State, consultant. Now they will tell you that this land, we've gotten government approval. Usually, they have a global C of O that covers the entire land that has been allocated to them. So the original title document for that land is that global C of O. Now, if there are about 4 plots, or let's say 1,000 plots, right, in respect of that certificate of occupancy that was given to that company to deal with, you don't expect that they will hand over the original title. There is only one original title document, right? And what the law says is that you have to hand over the original title document to the assignee. So now we are stuck. There are about 100 plots, and the company has sold to 10 different assignees. You can't have original title document handed over to each of these assignees. So this is where this clause now comes in. That is the acknowledgement for production and undertaking for safe custody. What are you acknowledging to produce? The original title document. What are you undertaking to keep in safe custody? The original title document. So, where applicable, an assignor who retains custody of the original title document covenants to keep that document safe and to produce it to the assignee whenever reasonably required as evidence to title to the land. So, just as we have said, let's say Chief Adeola now wants to perfect his title. Now we have gotten to the post completion stage, and that portion of land was covered by a global certificate of occupancy. In order to obtain governor's consent, Chief Adeola must present the original title document to the Honorable Minister of the FCT. Right? Now, since that document is important, the assignor has to hand over the original title document to Chief Adeola. Now, once Chief Adeola is done using that document to prove his title to that plot of land that Jumoke Kende had sold to him, is to return that original title document back to Jumoke Kende. So let's see how to draft this acknowledgement for production and undertaking for safe custody. The assignor hereby acknowledges the right of the assignee to the production of the document of title mentioned in the schedule hereto, and to deliver copies thereof, and hereby undertakes with the assignee for the safe custody of the said documents. So this has captured all we have explained so far. And this then brings us to the end of our discussion on the miscellaneous part of a deed of assignment. So if you have not subscribed to our channel yet, please do so and Share this video with your colleagues. I'll see you in the next lecture video where we'll discuss the concluding part of a deed of assignment. Have a wonderful day. Bye.